he basically said, you know, he knows he's the guardian ad litem's, you know, the advocate for the children.
Yep.
But he says he's relying more so on the different parties here. That I don't think he's going to say one way or the other to jump in the fight.
That's fine. What do you want to have happen, or what do you see happening next, Mr. Summerfield?
Judge, the court has clearly said that Ms. Thompson is in charge. It sounds like that is not being adhered to. It's causing issues. We have this new information. The department filed a report. This was prior to Ms. Thompson's information yesterday and the meeting where the children actually saw their mother. The report was positive. That's where we need to focus on. But I don't know why I'm asking the court to make it more clear than it already was, but that Ms. Thompson is in charge of, you know, the therapy, and we don't need other things happening that conflict with Ms. Thompson, especially when she's not been consulted. I'm not throwing Mr. Ballard under the bus. He's the new worker here today, but I think he is walking into something. This is something that is above him. Maybe the court, through, you know, has its own opinions about what has happened on in this case. I just find it hard to understand that a court order is not being followed. And I think it needs to be emphasized, if it hasn't already been clear, to make it clear today.
Where do you want to go with this? I understand that the information from Ms. Thompson about the meeting with the children and the mom yesterday is very,
Yes.
very new, and really nobody has had a chance to process it well yet. Do we need to have another review hearing in a 3 weeks or a month? Do you want me to just set a normal review hearing and then let the parties discuss things as they need to in the interim? What do you suggest?
I would like to see something. Ms. Thompson talked about they're going to have Thursday meetings, so we're not doing this Thursday.
Yes.
So that I think if we had a second meeting with the children and mom, we would have an opportunity to also gauge if the children are moving positively, or is there a reaction that has not been reported yet? We don't know that. But the department is in the court's view that this is something new and it needs to be explored. So as far as that needs to continue, and it needs to continue without any real or perceived interference with Ms. Thompson and her decisions.
Mr. Ballard, from the department's perspective, any issues from you?
No, I think the main thing was seeking clarification. My interpretation, I think, was incorrect, and I was under the impression that Ms. Thompson is leading the reunification, specifically reunification efforts, and not case management as a whole in all aspects of the case. So I'm honestly confused of where my role falls.
I don't know that that's your fault, and that some of that may be mine. I left my pronouncement when I made it in court very basic. I said, she's taking the lead.
Okay.
That doesn't necessarily mean that she manages the minutia of what your job is, but she takes the lead. She sets the tone, she sets the pace, she sets those things. And if you guys disagree, and I don't have any problem with differences of opinion,
Sure.
Obviously I'm a judge, I'm used to that kind of stuff, then bring it to me and we'll, or talk with Mr. Sommerfeld, and or have a mediation session, or I would love to see the parties all sit down on a regular basis. And in fact, I think that's what I'm going to order coming out of today is I'm going to ask Ms. Thompson, she asked for some specific court actions, establish a specific parenting time schedule, reinforce foster parents' role, assign case management oversight. She want to ask for that to be different, but I'm not going to change that. I'm going to say, set the parenting time schedule that you think is appropriate. Discuss in doing that, discuss it with all the parties and get their input. And then at least you've heard from them before you set it. And then I'd like to see it set in writing. And here's the plan going forward. And if somebody disagrees with it, we can bring it out and have a discussion about it either in court or at a mediation session or wherever we're going to go with that. But at this point, you're the only one that's got a breakthrough at all from the kids. And so I want to explore that. And so set what you need to set, discuss with everybody. And I mean, everybody, you know who the players are. Whether that's via email or whether that's, I'll let you, if you want to do FaceTime, I don't care how you do it. But corroborate with each other, talk to each other. If there's a disagreement, you're at this moment you're gonna make the ultimate decision. It's kind of like me. You guys all bring it. You get to disagree. Here's what I want to do. Here's what I want to do, and I ultimately have to decide. That's your job, and it's a thankless task. And but the big deal is let's see if we can get the kids back to their mom. And if it's not going to work, I think we're going to know relatively quickly. I'm not looking a year down the road. I'm looking 90 days. How, is there some glimmer of hope at that point? So do you understand where we're going with this?
Yes, Your Honor.
All right. So Mr. Delaney, I'm going to turn to your client next and say this. She needs to improve 100%. I'm not gonna put these kids and all of these people through all of this just so she smokes herself into having no lungs and can't make it back, or she doesn't have a home for them to go to, or she has a partner that's involved in domestic violence. I mean, she has got to step up. Have I made myself really clear? I mean, I hope that you can see how far I'm sticking my neck out for you to have an opportunity to get your kids back. If I were doing things like a judge normally would, it would be done. We've been way too long at this. These kids are having too many problems. Okay, so I'm really sticking my neck out here for you to have a chance to have your kids come back to you. So you have got to pick it up. I can't have any, the department calls them barriers. I can't have any crap in the way. That means if they ask you to do something, you say, yes, sir, and how high do I need to jump? And then you clear it by double what they told you to. I can't make it any clearer than that. You got to give up the cigarettes so that you can live long enough to have your kids. Because I'm not going to have you die tomorrow or the day after I put the kids in your house. That's silly, right? That's putting yourself in front of your kids. Don't do it. I can't have, I'm not going to tell you who to have a relationship with, but if you're going to have a relationship with somebody, he's got to jump through the hoops just like you do. And if he's not willing to jump through the hoops and you're not willing to kick him to the curb and take your kids instead of him, then you don't get your kids back. That's as simple as I can make it. Okay? If you don't have, we've been talking about the beds in the house for how many years now?
They're there.
The last thing I heard though was they're not together so that kids can sleep in them.
They are together.
They need pieces and parts yet.
They need one plyboard,
Well,
that's it.
Why? Why do they still need that?
Because I didn't have a vehicle to transport the stuff, now I do.
Okay, so here's the deal. It's time to put up or shut up. I don't want to have any more whys. Get it done.
Okay.
At the end of story, get it done. Okay, because as fast and as hard as I'm making them work, if you hold things up, I'm just going to say, I'm out of time and you don't get your kids back. And that makes it easy for everybody. Then you can go do whatever the heck you want in whatever pace you want to do it at. If I made myself really, really clear.
Yes, sir.
Mr. Delaney, you understand what I'm talking about, right?
Yes,
I hope that you got it.
and Melanie's here too, and her
Yes.
mom.
So
So
have I ticked everybody off yet?
No, not at all.
I wanted to add a couple things. Since
Can we address the fact that since the last hearing, Elizabeth quit smoking marijuana? It's not coming up in our system anymore.
I see that she's doing
Thank you.
better, and I apologize if I don't
She does
apologize.
improve.
I wanted you to be afraid of me, and I still want you to be afraid of me. But I understand you're doing better, or otherwise we wouldn't be here. Okay, so when you walk out of here today, don't think that I'm just mad at you, but I am mad at you. Okay. All right, Mr. Delaney, anything else?
I think, the court's covered quite a bit. I just wanted the court to know, we decided we did not need mediation. And as the court pointed out, we avoided a contested hearing by talking. If everyone did that, you don't have to work 2 days a week, if that, but that's not gonna happen. So.
Yeah, if you can work that magic on the rest of my docket.
We do that. So I appreciate what the parties did in the 20 minutes that they were here. It's my view that we don't need an immediate review hearing. And, maybe Ms. Thompson wants to weigh in on, give me this much time and I'll come back and tell you how we're doing. A week's not going to be enough. Is 30 enough? 60? That's number one. Number two, does Ms. Thompson have the tools that she needs? Obviously, she disagrees with Child and Family Services, but then she's the leader here. And I say that because I don't want to get more. I enjoy talking to the counselors, more communications from them saying it's not working. It's 60 days from now, and I still have this impediment. So maybe that's more a dialogue between the court and Ms. Thompson right now. I know the department's going to look at that issue, but I'd like to leave here today with a path between Ms. Thompson and Child and Family Services, and I don't have that.
All right. Let me just say it this way. I want, and Ms. Thompson can tell me if you can or cannot do this. I want you to talk to everybody, number one. Number two, I want you to put what your plan is in writing and send it to everybody so they can comment if they need to. And then I want you to do it to the best of your abilities. And if anybody else disagrees, they can file whatever motions they want to file. We'll talk about it again in 91 days at our normal review hearing. If somebody has an emergency, if the kids, one of their heads explode because of whatever issue, fine, take it up as on an emergency basis. But until their heads explode, I think I used the analogy when I said you're taking the lead. You got to rip the scab off. So now's the time. They're here. They prepare as best you can. I mean, be a good bedside manner doctor and do it the least painful way that you know how. But if there is some pain, then so be it. We've got to go through it to see if it's going to work. I think it's worth it to put family back together again. If we can't, we can't. But if we can, I want to explore every option to do so. That's as clear as I can make it. If that's clear as mud, and so be it. All right. Thank you all very much. I appreciate the extra effort today. Thank you very much.
Judge, I have a 3 o'clock. I'm just going to stay
Please.
and burden you with my presence. So
No, we are always pleased to have you with us.
same here.
We are on the record in the matter of Pace children, Seth and James. It's file J23-212-NA. If I could have the appearances of the parties, please.
Don Sommerfeld for the Department of Health and Human Services.
Thank you.
Blair Brown on behalf of Zach.
Thank you.
Donna Hansel, BFF Children.
All right, I do see Ms. O'Neill from Wellspring, and I do see Zach Pace is with us as well. I have read and considered some documentation filed previously, which includes the case service plan from January through April of 26, parent agency treatment plan from January through April of 26, and the Wellspring court report, updated court report. Any other documentation I should have had to review, Mr. Sommerfeld?
No, Judge. That's
All right. Any objection to that being considered by the court?
no objection.
No objection.
No objection, Your Honor, but just for the record, the only document I received was the court report. I received that this morning, I believe. I did speak with Mr. Pace the other day, but I did not have the report when I went over anything with him.
I apologize for that, Mr. Brown. We will get that information to you as quickly as possible. And if you need,
I'll forward it, Judge.
thank you, Mr. Sommerfeld will get that to you. And if you need anything after you've had a chance to review that, please let me know and we'll schedule something for you if there's something important that you think needs to be resolved or reviewed.
Thank you, Judge.
Mr. Sommerfeld, do you have a witness for me this afternoon?
Yes, I'd like to call Delora O'Neill.
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you very much. Your witness, Mr. Sommerfeld.
Thank you. Miss O'Neill, can you say your name, please, and spell your last name?
Delora O'Neill, O''Neil.
And how are you employed?
I'm the foster care program manager with Wellspring Lutheran Services, and I'm the primary worker on the PACE case.
All right, and the documents that were identified today, are you familiar with them?
Yes, I am.
And didn't you author them also?
Yes, that's correct.
Larry, I've just sent that to you.
Thank you.
So the current goal here is juvenile guardianship for both kids.
Correct.
Okay, and then mom, she voluntarily released her rights.
That's correct.
And so your court report explained that, I mean, do you believe that Mr. Zachary Pace, you know, he understands the projection in this case of what's going to happen?
Yes, I do believe he understands that the children will be staying in their current home with the foster parents. With a goal of guardianship, he would be allowed some contact with the children, but that it would be at the discretion of the guardian.
Okay, is he still having contact with the children at this time?
He is.
Okay, and have you witnessed that, or do you have any reports of how that may or may not be going?
I have not witnessed visits since they were moved to the weekends, which was at the foster parents' request. So the visits are now occurring in Gaylord only one time per month with the foster parent supervising, and she reports that the visits do not go well. They're quite chaotic, that the boys become dysregulated, and so then Zach struggles to redirect both boys. They can be a real handful when they get dysregulated, particularly Seth.
All right. So other than that, the report indicates that the kids are both, they're doing okay at this time?
Seth has significant needs, and James has some minor needs, but the foster parents are able to meet the boys' needs, yes.
Okay, do you believe that their placement with the foster parents and the prospective juvenile guardians is in the child's best interest?
Yes, I do.
Okay, can you tell us why you believe that?
These foster parents are very attached to both boys, and the boys are bonding to them. It's a safe home for them, and the foster parents are very strong advocates for both boys, ensuring that they are the services that they need are being provided, and that all their needs are being met. And the boys are very bonded with the foster siblings in the home as well.
And so are you saying that if we were to compare and contrast Mr. Zachary Pace's his ability and his conditions at this time versus the foster parents are in a much better position to provide for the children?
Yes, that's correct.
So this juvenile guardianship, is there a wait period currently?
Seth has been in the home long enough for me to apply for the guardianship, but James has to be in the home for 6 months, and he was placed on the 7th of January. So I cannot apply for guardianship for James until after July 7th.
Okay, so aren't there ways to expedite that or exceptions?
The rule is that they must be in the licensed foster home for 6 months before we can apply for guardianship.
Okay, so are you planning to make the request for juvenile guardianship when when James is available?
I would be, if I can get all the paperwork together for Seth, I will submit that sooner, but for James, I have to wait until July.
Okay, and so are you planning then to potentially have one child approved ahead of the other child?
I am.
Okay, and that was really my question. Thank you. And so do the children, do they interact okay with each other?
They do. There's a little bit of normal sibling rivalry and jealousy, but other than that, they enjoy, I think they're both really happy to be back together in the same foster home for sure.
Okay, can you describe an example of each child as their relationship with the foster parents?
So this is James' fourth placement and he's quite little. He's allowed to spend one-on-one time with the mother because he's the only one not at school. So he's very much attached to her. The foster mother was just telling me that he had gotten in trouble a little bit and was told to sit next to the foster dad, and he was quite upset that he wasn't able to sit next to the foster mom. But he definitely is calling her mom, goes to her to have his needs met, and definitely shows an attachment. Seth calls the foster mom his best friend to his therapist. He goes to either foster parent to have his needs met. And just when I observe them in the home, they both appear to be very well cared for and appear to feel secure in the foster home.
Okay. So at this point, we're kind of like in a holding pattern for to complete the goal of juvenile guardianship for both Seth and James.
That's correct.
Is there anything else you'd like to offer today?
Just in regards to the visits, the foster parent is requesting that we only have one face-to-face and that the phone calls be ended. We were having weekly phone calls as an adjustment from weekly in-person. Seth has actually asked that those phone calls stop. And because he's doing a lot of wetting and soiling his pants and being teased at school, the foster parent would like to try just one face-to-face and no other contact to see if that will assist with his dysregulation.
Okay, and you're talking about having contact with that.
Correct.
All right. Anything else?
No.
I have nothing for the judge.
Mr. Brown.
Just one quick question. Ms. O'Neill, I did actually get the court report. You mentioned under the parent status, Zach understands the permanency goal for his children is guardianship. This has been explained to him on multiple occasions. Is he not understanding what a guardianship is? Does he think the goal is something different? I'm just wanting a little clarification on what you meant by that.
That's just my trying to reassure myself that Zach understands the goal of guardianship. And so when I meet with him monthly, I just try to make sure that he understands that this is permanent, that they will be staying where they are, and that the contact will be at the foster parent's discretion. And I believe that he does understand that.
Okay, that's all I had. Thank you.
Ms. Hansel, questions?
Yes, just real quick. As you stated earlier, Seth is in therapy or counseling through the school. Is that correct?
Correct.
And Seth is in kindergarten?
Correct.
Okay. And both boys are being tested for autism. Is that correct?
Correct.
Okay. And do you know when is that scheduled yet, or is that something that's just being planned, or do you know?
So I spoke with the foster parent this morning. James's assessment was completed yesterday, and it was determined that he does not have enough markers to be diagnosed with autism, but that he definitely has some concerns. The referral has been sent over for Seth, but the appointment has not been scheduled.
Okay. And if I understand the foster mother correctly, the soiling and wetting his pants at school for Seth increases around when he has parenting time or the phone calls or the face-to-face visits. Is that correct?
She does believe that Wednesdays and Thursdays are the worst days, and the phone calls are on Wednesday evenings.
Okay. So prior to the more steady contact with the father, is it your understanding that Seth wasn't having as much problem at school with that?
He was soiling himself on the way to the visits or shortly after the visits when they were occurring here in Gaylord.
Okay. All right. And James walks on his tiptoes. I'm
Correct.
in that. Okay. And is there some concern, or is he being checked out for any type of medical reason for that, as far as muscle development or anything, or do you know?
I know that she brought it to the pediatrician's attention at his 3-year appointment.
Mhm.
And the indication, she thought it might be an indication of autism, so he was referred for the autism. So
Okay,
at this time, it's not been, it hasn't been ruled out, but it hasn't also been
Okay.
stated that it's a medical reason.
Okay. All right. Thank you. I have no other questions.
Ms. O'Neill, I have just a few questions. Could you help me understand how the supervised parenting time with dad and boys is going? Like, where is it done at? Under what circumstances? Describe it in a little more detail for me.
The first visit that was here in Gaylord on the weekend was held at Burger King, where there's a play area. So the foster mom was trying to monitor. The boys come to her continuously rather than going to Zach, which she's trying to, distance herself enough, but it was a real struggle, and she felt like Zach couldn't spend a lot of time with the boys because they were up on the play equipment. So this last weekend, they went to an outdoor park, and she said that was very difficult for her because she felt that Zach wasn't monitoring the boys' safety, like they had gone up on a step and she was afraid they were going to fall. So, and if they were running, it would be difficult. So she felt like it was too chaotic and very stressful for her to be outside in the park with both boys and Zach.
I wrote myself a note, and you just hit exactly what I wrote myself a note about to see if that would be helpful to try those things. I guess I am looking for something that allows the foster mom to keep the boys somewhat well regulated, but also allows dad to see the boys. And maybe as time progresses, he can move into having a little more interaction with the boys. So I was hoping that the park idea would be something, what is the Sportsplex has a kind of a play area, which is, I believe, fenced in, or
Yes.
mostly fenced in. So the idea of them just running away is a little bit lessened that way. I'm wondering if there's an opportunity where a worker could be there for the next couple of visitations to add a little bit of supervision with the foster mom and with dad. I'm just looking for, and I don't think I'm going to include it in an order, but I'm just looking for ideas that could be used to help dad get to know his boys and continue to have a contact and a connection with his boys, where it isn't causing the boys such emotional dysregulation. I don't think that's good for them. Certainly not good for mom, probably isn't very good for dad either. So if you would give that some thought, talk it over, maybe with Ms. Hansel as well. I know she's got a good head on her shoulders as the guardian ad litem. Maybe she can come up with some other ideas or places or circumstances. If there was, instead of a phone call, and I know the boys are probably a little young for this, but if there was a video game that they could play with their dad, that might be something that they can do together that would be a little up their alley a little bit. And again, it may be too old for them at this stage, but I'm looking for ideas like that where they can game together or play together or be in the same place together. If foster mom is taking the boys to a zoo for the day, Zach may be able to tag along and stay in the background and let her shepherd the boys through, but he can watch and he can interact, at least be part of the process, and then over time have that develop a little bit. So I think you got the idea where I'm trying to go with this. So I'll just kind of leave it with that. All right, I don't think I have any other. Well, yes, I do. One of your recommendations is that Wellspring no longer be required to provide services for Zach, given that the juvenile guardianship. are there services that he could benefit from that Wellspring has, or are you saying that there aren't any further services that are likely to give him any benefit?
Zach has participated in the services that we were able to provide. He would benefit from some individual therapy, but he cannot participate just simply due to him not having any medical insurance. So, and I believe that all the parenting classes that we've provided him, he's done. So I don't feel that there's any additional services at this time.
All right, thank you. I just wanted to make sure I understood the reasoning behind the recommendation. So, all right, I have no further questions. Mr. Sommerfeld or anybody else, any questions based on mine?
No, thank you.
All right, your next witness or any other additional witnesses or evidence, Mr. Sommerfeld?
I have none.
All right, Mr. Brown, any witnesses or evidence?
No, Your Honor, thank you.
Ms. Hansel, any witnesses or evidence?
No, sir.
All right, I'll take closing statements. Mr. Sommerfeld?
Judge, I'd ask the court to continue the goal of juvenile guardianship through the testimony and the documents submitted today. I believe it represents to the court, it is in the child's best interest. We know that mom voluntarily released her rights. Mr. Pace was in a different circumstance, and I believe that the juvenile guardianship it suspends his rights as parent, but it still does not extinguish that, and the placement will provide the permanency that the children need to grow up.
All right, thank you very much. Mr. Brown?
Your Honor, I would agree with that. I would agree with the recommendations. I think he is doing much better. I will leave it at that. I am in favor of the guardianship.
Thank you. Ms. Hansel?
Your Honor, I'm in favor of the guardianship as well. I think it's a good answer for this situation. The boys do seem to be doing very well in this circumstance. I was a little worried at first when James was first placed there, how he would blend in, but it seems to have went very well. I mean, they have the typical issues, but for the most part, it's been pretty smooth. And I do believe that the experience with this foster family, their history and their experience has shown through this. I believe they're doing a good job with these boys.
All right, thank you very much. Zach, is there anything that you want to tell me?
I do have a question, and then I do want to add one thing.
Go right ahead.
So with the counseling thing, I am still seeing Jeanette. It's just she's got my my payment thing on hold right now until I can get the insurance.
Okay.
And
Good.
then oh, go ahead. I'm sorry.
Go ahead, finish up.
Okay. And then I know the guardianship is the plan. It's just I've had this question flow in my head for a minute. So like if there was ever a time where them coming home was an option, what would I have to do?
You would file a motion to modify or terminate the guardianship. That is to take off the guardianship or change the guardianship. And then the judge would decide whether that was in the best interest of the boys at that time. So you would always have that option if you needed it in the future.
Okay, yeah, because more and more families starting to come around. So I just wanted to ask.
It's a good question. I thank you very much for doing that. All right, I do believe that we are pointed in the right direction. I think things are going about as well as we could expect this time. So I will continue the goal of juvenile guardianship. I will order that Seth and James remain under the care and supervision of the court and Department of Health and Human Services under the supervision also of Wellspring Lutheran Services, that the boys remain in their current unrelated licensed foster home until their permanency goal has been achieved. I think that the parenting times, I will order that the parenting times for Zach remain supervised and the frequency of the visits be at the agency's discretion, with the understanding, as I put it on the record for Ms. O'Neill, to work on things as well as she can. And then I will order that the services by Wellspring for Zach no longer be required given the goal of guardianship. If there does come up something, I would simply ask that Ms. O'Neill do whatever she can to make recommendations for Zach, that he can find that voluntarily at a different place or through insurance if he comes to have that in the future. Anything else, Mr. Summerfeld?
No, thank you, Judge.
Mr. Brown, anything else?
No, Your Honor. Thank you.
Ms. Hansel?
No, sir.
All right, good luck to you, Zach. I hope things continue to go well. Thank you, Ms. O'Neill. Appreciate the time and efforts for this. That will be the order of the court. The court will be in recess.
Thank you.
This case on the court docket is that of the Hesselmeyer and Baughman children. That's file J25-326-NA. If I can have the appearances of counsel, please, Mr. Summerfeld.
Wisconsin, I think, for the Department of Health and Human Services.
Larry Brown on behalf of Jenny Scott.
Mr. Delaney.
David Delaney for Father Skip Bowman. I've not had contact with him. He's not here in court, and I don't think I do not see him on the screen.
All right, my staff is letting me know he's not here, so let me make sure I got everybody. Mr. Brown, you have Jenny Scott, is that correct?
Yes, Your Honor.
All right, thank you. I do see Mr. Hesselmeyer is present. Ms. Scott is present as well. Do we have a plan this? No, this is down. This is a Mr. Dowling. I don't recognize it.
Just jumped in. 1 second. Here he comes.
I have my headphones if you can't hear it good. It's okay.
Mr. Dowling, are you present with us?
I am, Your Honor, yes.
I'm not able to see you. Can you turn on your camera, please?
Trying, Judge.
Just for everybody's information, we're having a connection issue with Mr. Dowling, so we're put him in the waiting room and bring him back out, see if that helps. You had any success yet, Mr. Dowling?
Not yet, Judge. I'm still trying.
Let's see.
We have to just go with just
Hold on.
I typically use a hammer.
What you feel like doing? Okay. Dad.
Judge, I'm just not seeing where it allows me to change anything. Could I just
Well, hold on here.
just appear verbally?
Yeah, we'll do that if we can. It's always nice to be able to see each other, but if we can't do it, again, there's typically what looks like a little video camera button. But if not, we'll go ahead. If you find it later, go ahead and push it, and we'll greet each other then. So,
Judge,
all right.
it says it's
Yes.
disabled by the host. It says this camera is disabled by the host.
Well, we can try to fix that.
Okay.
Thank you for letting me know.
Yeah.
You good now?
Yeah, I did that so that it would let me hit F to start video, but.
All right. If you're able to find a video button, Mr. Dowling, go ahead and try it, but we'll proceed otherwise.
Thank you, Judge.
All right. We are here on a pretrial hearing for mom, Jenny Scott, and a review hearing for dad, which would be Mr. Baughman, who's not present. And let me indicate the reports that I've received already. I have the MDHHS review report dated 4/27 of 26, case service plan between October and January of 2026, October 25 and January 26. Parent agency treatment plan for that same time period, October through January. Case service plan, from January through April of 2026, and the parent agency treatment plan from January through April of 26. Mr. Sommerfeld, is there any other documentation I should be aware of?
No, you have it all, Judge.
All right. Any objection to those documents being admitted?
No objection.
No objection.
All right. Those documents will be admitted. As to the review hearing first, Mr. Boffman is not present. Where do you want to go with that, Mr. Sommerfeld?
Has he been properly served? Otherwise, I do have a witness to present some brief testimony just to supplement what the court has already received as a form.
I have a notice of hearing for today's date, April 28th at 3 p.m. In the courtroom via Zoom for that was mom for the pretrial hearing. Can you find proof of service on the computer faster than I can in the courtroom?
I'm working on it.
Judge, notice was sent and we don't have anything showing it returned to the court as undeliverable. I would the department would be comfortable to proceed on that.
Well, I can't find a proof of service at all at the moment. Although you all are here. I got an adjournment. This the pretrial doesn't list the dispo hearing. I've got two different things for today for the pretrial hearing, but none for the dispositional hearing. So we're going to skip the review hearing, just move the pretrial, and send out a new notice on the review hearing. Sorry for the inconvenience, I apologize.
Judge, there is another issue we need to bring up involving Miss Casey's contact with the Hesselmeyer children with the non-respondent parent.
Yes, we'd actually like to comment on that as well.
All right, let me figure out which I need to do first, and then I'll let all the parties have their say as to that issue. Is there some reason that needs to go first before the pretrial on the mom?
No, we could do the pretrial first, Judge.
All right, let's do that. Mr. Brown, how does your client, Ms. Scott, wish to proceed as to the adjudication or plea?
Your Honor, we were not really, she doesn't want a trial, but she also is not going to plead. So I don't think really have any
That would be an
choice,
interesting-
but yeah.
That's an interesting way to proceed. So what
I
would
don't
you like
think,
to do?
well, I don't think I have a choice other than setting this for a trial, Your Honor.
Ms. Scott, I know that you're trying to talk, but you're on mute at the moment.
Okay, I apologize. Your Honor, I am demanding a hair follicle test. Literally, that is all I want. I want a second opinion for my psych eval from somebody I pay for out of my own pocket, not provided by the state of Michigan. And I want a hair follicle test.
What stops you from getting a hair follicle test?
Honestly, I don't know where to go and how to go about it and do it. So I now want to do it to prove that all these allegations are wrong.
All right, Mr. Brown, Mr. Sommerfeld, are you familiar with a lab where hair follicle tests might be done? Or would DHHS have options to that?
Well,
Would not be at DHHS cost.
what would I don't know what the hair follicle test would be for. Is that for testing?
Because they are trying to say that I have substance abuse and I'm an alcoholic. And I'm not. I haven't drank in years. I don't use substance. I've been clean for 5 years since I left Skip Buckman dying at 60 pounds, locked in a room.
All right.
That sounds like a trial issue to me, Judge.
It does, but I want to make sure that she has the ability to put on a defense if she wishes to put on a defense. So I'm simply asking for information. Is the department or yourself aware of a lab where she could contact and have that done?
We could try and find one, Judge. The allegations, I don't believe they're for current drug use. It's for allegations of things in the past. So I don't know really the relevance of her request.
Mr. Brown, are you, hang on, Ms. Scott, just a second. Mr. Brown, are you aware of labs that could potentially assist your client?
I am not right off the top of my head, Your Honor. I'm not that familiar with follicle tests. I did try to speak with Ms. Scott yesterday about this, that again, this petition is almost a year old.
I want to go to trial. I want to prove my allegations wrong. And so far, everybody has literally said,
Ms. Scott, we are discussing how that was going to happen. So if you slow down just a second, you'll see that we're moving in that direction. It just takes a little bit of time and we have to do things in order. And I apologize if it's going a little bit slow for you, but I will give you another chance to speak in just a minute. I just want to make sure I understand where Mr. Brown is going. So Mr. Brown, I'm going to leave this in your capable hands about whether or not you contact a lab and how you present a defense for her. I'm not going to order DHHS to take any action with that. That's not their role. My inquiry was simply, is there any available local information about that you could tap into? I believe that you could, when I was in Mount Pleasant working for the tribe as a judge there were a couple of substance abuse labs and clinics there. That might be a good place to start if you don't know of any others. I don't have names for you, but it was on the internet. If you just Google DNA labs and Mount Pleasant, you probably pop right up. So I'll leave that in your hands. We will set this matter for a trial. Are you asking for a bench trial or a jury trial, Ms. Scott?
Can you please explain?
A bench trial means in front of me as the judge. A jury trial means in front of 6 jurors from the community.
Just want to talk to you, Judge. That's it.
All right, we'll set it for a bench trial.
Judge, if I could just make a couple things clear. Mr. Brown said this case is almost a year old. The original petition was, I signed it on June 18th of 2025. We have recently filed a supplemental petition that is in relationship to both parents that was filed on February 27th of 2026 this year. It requests termination of parental rights. So while it would be proper, we have to go through an adjudication for Ms. Scott because we do not have jurisdiction over her. However, I know Mr. Skip Bauman is not here today. However, since he is already under the jurisdiction of the court, we would be proceeding on a supplemental petition under MCR 3.977. It would be F. And that would be based on the new allegations in the February 27th, 2026 petition.
What new allegations?
Abuse and neglect.
Ms. Scott, you can find those allegations in the paperwork that were filed back in February. And if you talk with your attorney, I'm sure that he'd be more than happy to discuss each of those with you so that you know what you're charged with. Mr. Brown, excuse me, Mr. Sommerfeld is simply pointing out that the case isn't quite as old as the comment was, and that's quite frankly not a big deal at this point. But the allegations that you need to be concerned with are in the February 2026.
Which is why I
petition.
want a second opinion with the second
All right,
psych eval.
and you'll be able to do all of that on your own and with the assistance of Mr. Brown if he believes that that's appropriate. So we'll
Yeah.
set a bench trial. It will be for a full day. It will be in front of me alone. That when notice will come out. I'm assuming, Mr. Brown, that you're going to ask for 60 to 90 days lead time to be able to prepare for that.
I would request at least 90 days, Your Honor, if she is going to want to get some of these other tests taken.
Thank
And
you.
I think that would be appropriate because the lab work is going to take some time. You're going to need to find out where to send it and how to do all that. So we'll do that. We'll set it for a pretrial conference 1 week in advance, just to make sure we've got things covered and no last minute details. Not as big a deal with a bench trial, but I want to make sure that we've got all our ducks in a row at that point so everybody can tell me how things are going. I will not need jury instructions at that time, but I will ask the parties to exchange witness lists and exhibit lists 14 days in advance of the trial.
What was the second one after witness list?
The witness and exhibit list.
Exhibit.
Exhibits are the documents or the other evidence that's put into court. And
I got a
Mr.
whole
Brown,
book.
yeah, Mr. Brown knows all about this. He practices in front of me on a regular basis, and this is one of my normal requests. So we'll do that. Any evidentiary issues, things with the rules of evidence will be motion at or before the last pretrial, so that we've got all that taken care of as well. Mr. Sommerfeld, is there anything else that we need to do as far as the pretrial goes?
Yes, Judge, since we have filed a termination petition, we're here for a pretrial today under MCR 3.977. It's capital D. It's called suspension of parenting time. I'm sorry, Judge, I misspoke. In the petition, the department alleges aggravating circumstances under MCL 722.638, both under number 1 and 2. It applies to Skip under 1. The allegation that he was the parent and he abused the child and it was by criminal sexual conduct. And then if that part is met, when you look at 2, it looks at the request for relief, where we would file a termination petition, and that would be for Skip. And also, if, as alleged in the petition, Ms. Scott, she had the opportunity, she knew of the abuse, she had the opportunity to prevent it, and she did not do so, there's also a request there based upon the aggravating circumstances that the department is asking the court to order that reasonable efforts not be provided based upon those aggravating circumstances.
All right. Mr. Brown, any objection to that?
Your Honor, I
Um,
believe,
Can I say something?
I
When
believe
he's
for
done-
parenting,
Ms. Scott, you have to give your attorney a chance to speak first. If you have a question or have an issue, I'll get to you in just a minute, but you have to let your attorney go first. Go ahead,
Okay,
Mr.
thank
Brown.
you.
I believe her parenting time was suspended back in September of last year. As far as continuing to provide services, I have not spoken with Ms. Scott regarding that. I would object to that, but again, it's a general objection. I have not really spoken with her, had that opportunity to have meaningful communication.
Ms. Scott, do you have something that you need to say about this issue?
Yeah, Skip Buckman was military trained and I was locked in a room at 60 pounds. I didn't have ample time and I got proof of it.
All right, Ms. Scott, you're going to have a chance at the trial to bring out any defense that you want to bring out. So that's not what we're talking about today. The request from the department was what are called reasonable efforts in providing services while the case is pending. And so because they have alleged under the statute, because they've alleged that there was criminal sexual conduct by the dad, and they have alleged, they haven't proven it yet, but they've alleged that you failed to protect when you had the opportunity to. You'll be given an opportunity to contest that, but that allegation is, so they're asking that they not provide services to bring the kids and you back together again. And it makes sense because there's been a suspension of the parenting time. So it really isn't going to change anything that happens to you. It's just a matter of DHHS not providing services. If they can't prove their case, and if you are successful, services would be reintroduced at a later time. If they are successful, then there would no longer be a need for services in the future. So I think it would be appropriate at this time to enter an order as part of my order that DHHS not provide further reasonable effort services until such time as there's a determination at the trial. Anything else, Mr. Sommerfeld, for pretrial purposes?
No, and if the court order to be clear that that's based on the preliminary finding of, much like if we would have filed this petition first, if this was our first petition, we would have made that same request based upon the allegations under MCL 722-638, both subsections 1 and 2.
So,
all right,
Your
thank you
Honor.
very much. The court order will so note that's statutory subsection.
Thank you, Judge.
All right, now we are to the issue of that Mr. Sommerfeld wanted to address involving the two children that are with Mr. Hesselmeyer. So I'm going to let Mr. Sommerfeld go first, and then Mr. Hesselmeyer, I'll give you the floor and let you tell me anything else that there is for me to know. Mr. Sommerfeld, go ahead.
Judge, thank you. Judge, in this case, back when we filed our original petition back in June of 2025, last year, there's been issues. We have non-respondent parents. The department is required to meet with the children at least once a month. There's been issues with that has not been happening on a consistent basis. This was brought up with the court. I believe it was in front of Judge Cooper at the referee stage because it was at the preliminary hearing. My notes indicate we're talking about August 19th of 2025 last year that this issue was brought up. We've had some success based upon the referee speaking to Mr. Hesselmeyer to make his children available. Now, Ms. Casey has told me that she has not missed.
I missed a visit with Arian last month because he was AWOL.
So,
and then this month, I did not receive communication time.
I don't know that they're going to be able to hear you unless you speak up just a little bit.
I didn't know if I was allowed to talk
Go
right
ahead.
now. Okay. So essentially, they have been allowing me to visit the kids. The issue is that the communication with me is not on a timely basis. So I got notified yesterday after hours, so not until this morning, that I could see the kids tomorrow at 6 p.m. I am not available to do that any longer. I send them a list generally at the beginning of the month when I'm able to visit. I ask them to respond as quickly as possible to let me know what date and time would work best for them. I usually don't get a response until a couple days before or the day before of when I can visit. I have a lot going on with
Give you as much
cases and then also in my personal life because they requested an after hours visit, which I'm fine with accommodating, but I need better notice. And I do. I'm
Your Honor.
asking just for 5.
I'm going to let you talk in just a minute, sir. Let her finish and then I'll let you go.
All I'm asking for is 5 days notice, 5 business days, so a week in advance so that I can make appropriate plans between my cases and then my personal life so that I can see these kiddos. I recognize that they do not want me to come see the kids. They are with their dad, they are taken care of. I'm sure that's what they're gonna want to talk to you about. And I get that. I know they don't want me there and that's fine, but they're always respectful when I visit. I just need more notice.
Yep. Mr. Hesselmeyer, your thoughts?
Your Honor, it would actually accommodate both of us better if instead of having to have a 5-day notice, we just reduce the amounts of visits because it's already been detrimental the entire time to the children. They don't want to speak to her anymore. She keeps dredging up stuff. She's not a professional counselor. She's making my children relive these things over and over and over again. I honestly think once every 3 months maximum, possibly once every 5 months, because we don't really need to speak with her. We aren't the bad people who got in trouble, who did something wrong, that even need the CPS to come visit us over and over and over again, Your Honor. It's neither one of the children want to speak with them. It's not just Miss Casey. It's not just in particular her. It's they literally don't want to talk to him. He's already got a probation officer that he's speaking to. He's been doing his counseling the last few visits, and he's been doing remarkably better. We worked out a great understanding on some of the issues he was having, which he was AWOL. He left a note as you told him he was allowed to do when he needed to. He did leave a note when he left. They're now trying to use this to manipulate the situation further, as they have done in the past, by connecting his criminal trials to the parental trials somehow. And CPS managed to link themselves into both so that they could run their mouth and talk all they want at both trials, which honestly, one of them had nothing to do with them in the first place. The probation is already monitoring him. They're already taking care of him on that situational level. The counselor is speaking with him to take care of him emotionally and any of his concerns and traumas. We don't need them anymore. Honestly, the last time that they kept speaking to him, the only reason they did was they were hoping that they would assist us with the gym membership, which I'm not even sure if they ever did, because the last 3 or 4 things that they've held the kids that they were going to do for them, they never did. She's promised them bikes. She told them once that we would go bowling, and then there was a league there that night. Like, why would you set it up with us in advance? She went and got Aiden from Clio all the way downstate by Flint, and
Okay,
getting without making this.
Mr.
a plan,
Hesselmeyer, slow down,
right?
slow down. I
Okay.
know that you've got some grievances, but this is not the time or the place for all of those grievances. So I get it.
There's never been a time or place, sir. Every judge has told me, oh, well, it's not time to talk about this now. It's not time to talk about this now. And I never get to talk about these things. I got to make them known to you, or else it'll keep getting over.
I'll agree with that.
Thank you. I appreciate that. They don't need CPS in their life anymore.
Ms. Scott, I don't need people yapping when it's not their turn to talk. This is not the street corner where everybody gets to talk all at the same time. You had your chance. Mute her, please. All right, Mr. Hesselmeyer, I can appreciate your frustration, but there are certain rules that have to be followed, whether you like them or not, whether you think that they're good or not. I don't make all of those rules. As a judge, all I can do is say, I try to make things as easy as I can for everybody, but there are certain things that need to be done. One of those things is, while the case is pending, CPS has to put eyes on your kids because they're under the court's jurisdiction. And I have given them the ability to do that. I don't have the ability personally to come out and say, hey, are your kids still okay while the case is pending? That's what MDHHS does for the court. That's one of its roles. I get it that it has other roles as well. CPS is one of those roles. That's not exactly what's happening here. This is just making sure that the kids are okay. It's checking in, seeing what the kids are doing, making sure that no circumstances have changed, seeing if there are any other services that could be used or available, and making sure that the court knows about those things. Mr. Hesselmeyer, hang on. I'm talking. I gave you a chance. You have to let me finish with things, and then I'll let you speak again. And again, I know that you believe that the government is against you in many ways. I understand that about your worldview, and I'm not disparaging that. I'm simply saying that even with that worldview, I, as a judge, have to do certain things. And one of those things is I have to have DHHS at your home on a monthly basis, seeing that the kids are okay. That's what they're there for. That's what the court process requires me. Again, I think that you'd be angry with me if I weren't trying to make sure that your kids were okay and one of them got hurt.
If they were in a dangerous place.
I didn't say that it was, but life happens. Bad things happen. You were gone from your previous place where you lived in Genesee County, and you went to Kalkaska, and you didn't tell us. We didn't know where you were.
In the middle of
all I'm saying is that's an example where nobody was doing anything wrong, but the court didn't know where the kids were. And that, as a dad, I would think that you would understand that if you don't know where your kids are, if you don't know where the people are that you're responsible for, that causes you to worry. So it causes me to worry because I'm in a responsible role for you and for those kids. So I have to have somebody check in on a regular basis and say, yes, they're okay. Nobody's trying to pin anything on you. Nobody's trying to pin anything on the kids. We're simply saying, are they where they're supposed to be? Dad, are you having any troubles that we can help you with, that we can give you services? Do you need anything from us while we're getting the case ready and getting everybody through the case? You have, over the last few months, been cooperative with the court. And I appreciate that about you. And in the beginning of this case, I was wondering whether you were going to do that or not. And you have. And so I'm giving you the benefit of the doubt now. And I'm simply asking that you do that to me as well. I have a responsibility to make sure that the kids are okay. It's not me saying, hey, I think dad is doing something wrong. Go out there and investigate it. It's simply eyes on. Everything looks good. There's no services that they're asking for. There's no services that we think that we have that we can give them. Therefore, everything's good. Does that help at all?
Yeah, I understand exactly what you're saying, sir, but it's literally putting me in danger of losing my job. It's one more day that I have to go leave early from work, and on top of all the other days that I have to take off to deal with the court situations in general, with his other stuff, to deal with his counseling. I have to go and take him in person. I have to be there with him. So I'm taking off those days. The same for probation. I'll have to take off half of a day or an entire day to drive him to Gaylord and back because we couldn't get him into Kalkaska probation. So I've missed 3 hours today of $42 an hour work that I will not be able to make up. And
Mr. Hesselmeyer, I heard, I apologize for interrupting there. I'm sorry about that. I heard DHHS say that they can make themselves available after hours. So she may be able to adjust her schedule so that when you are normally home with the kids, she can stop in, but she just simply needs a longer period of time ahead of time to schedule that. So she would adjust her normal work schedule instead of 9 to 5 to be noon to 8 or whatever the time period would be required. She just needs a longer period to do this. So nobody's asking you to miss work. We're simply asking you to do a better job of scheduling it ahead of time so that she can make that after hours connection with you.
Yes, Your Honor, I understand that. What I'm saying is she gave me a 1-day notice to give her the response. I gave her the next day notice, and that's not good enough for her. I get it. I understand, but what I'm saying is that she just only offered the later services last week or last month when she
so going forward, that sounds like a workable deal, right?
Right, because I cannot get out of work before 3:30 ever.
All right, so
unless sometimes without leaving work early.
Let's start right now. The next meeting. When is a good time to be available after hours? What time do you propose, Mr. Hesselmeyer? What day and date and time?
Without knowing your schedule, we don't know.
Honestly, I have to look my schedule over and figure that out because I don't know. I'm doing so much.
Can you do that? Can you do that right now? Can you
Yeah.
do that right now so that we don't have a problem scheduling it in the future? And then at each one of the next hearings or each one of the next meetings, you can schedule the next one so that everybody knows ahead of time when it's going to be and where it's going to be. And we don't have these issues that pop up like that.
Can we look up real quick to see what the minimum amount of visitation that they can produce is? Because that would be the best for us. Every 30 days is the minimum.
That's what I'm asking. Every 30 days. What's your schedule?
It's still too much to have them in our lives that much.
Mr. Hesselmeyer, you're not going to be given a choice. You're in the court system, whether you like it or not. I'm working with you as best I can. You got to cut me some slack. I get it that you don't like it. I can't help that. They're under court jurisdiction. They're under court jurisdiction. This is what's going to happen. Whether I have to do it the easy way or the hard way. If I have to do it the hard way, I'll make you be here. I'll make you come to Gaylord. I'm not trying to do that. I'm not trying to be the bully. I'm not trying to beat you over the head with this kind of stuff. But you've got to work with me or bad things are going to happen.
I have been working with you, Your Honor.
I understand that, and I told you I appreciated that, and I'm doing what I can to work with you. But you can't say I'm not doing it at all. That's just not allowable. If I have to make orders, I will make orders. I'm trying to work with you here, so please continue to work with me. Once every 30 days is something that can be done. I'm giving it to you after hours, so you're not missing work. This is not an onerous request. What time and date do you want them to be there?
Thursdays at 6:30, if that's possible.
The latest possible.
The latest possible that they can physically give me so that I can have time to even feed my children before they show up.
Like the last 3 times.
The last 3 times we've been cooking dinner while they came in, and it's been quite a headache, Your Honor. And I'm hopping on one foot, spinning in circles, saying, "How high do you guys want me to jump here?" And they're every time we come in, they're just, "Oh, he's not working with us right," so that they can manipulate the situation further.
Mr. Hesselmeyer, do I look like the person that can be manipulated easily?
No, sir, and that's why
that's your answer right there. So they don't get to do anything. They're not going to manipulate anything while I'm here. Okay, but I'm also not going to have you tell me what the law requires me to do. So both sides got to give me a little bit here. So Thursdays at 6:30. When does MDHHS want to do its next one? We're looking at either the 30th of this week, the 7th or the 14th of May. When do you want to go?
Your Honor, Thursdays are a night that my kids play T-ball.
Okay. Is there another date that you can do that, Mr. Hesselmeyer? Another day of the week? It's
They
once
also-
once a month.
What is their latest evening that she can work out with us?
I'm fine with 6 PM or 6 to 6:30 PM. That's fine.
What day of the week is good for you?
Wednesdays would be the best. We could,
Give me 2 days and I'll have him pick which one's best for him. Wednesday or
you know what, Mondays actually would be best for me.
Monday or Wednesday. Which do you want, Mr. Hesselmeyer?
Monday it is.
Monday, 6 o'clock, 6 to 6:30. The day we're gonna
6:30?
start is, when do you want to start that? You start in May, or you want to start in April?
Can we start May the 4th? And can we just make it the first Monday of?
First
every
Monday
month?
of every month, starting May 4th. Is that all right, Mr. Hesselmeyer?
At
Yep.
6:30?
And you want it 6 or 6:30?
I would prefer
6:30.
6, but if they would prefer 6:30, that is fine.
6:30. Is that what you want, Mr. Hesselmeyer? 6 or
Whatever
6:30?
is
Which one?
fine at this point. I mean, 6:30 would be the best, but I'll take 6. I take whatever I can right now. Just
All right. May 4th, 6 o'clock, every first Monday of every month going forward until the case is resolved. Shouldn't be that much further down. Well, it's going to be 90 days down the road. So you're going to have to do three of these meetings is probably what's going to result in. So
can you ask her
anything else,
if they
Mr.
have paid
Summerfield?
the gym
I'm sorry,
membership?
go ahead. I didn't hear what you said.
Could you ask if they have paid for the gym membership that they promised my kids? So that they can start going to the gym?
Yeah, so she stopped making promises that she's not gonna keep.
Hang on. Who's talking in the background? Who am I listening to on your end, Mr. Hesselmeyer?
I'm not sure. What do you mean?
I hear you repeating what they're saying. So somebody's there talking and they're not on camera and I don't know who it is. So they're either going to get on camera and talk to me or they're going to be quiet.
There's the 3 of us here.
As to the gym membership.
Your Honor, the full picture to that is we did get approval to pay for them to go to the Coliseum. We got an approval to do a year membership, to do the pro-social stuff that you were talking about at the delinquency hearing. It took them several months to get the account set up that I needed for them to set up. I do need to call and get the gym membership paid for. I have not had an opportunity to do that, but that I found out at the last meeting.
But that's part of the delinquency case and not part of this case, right?
It was just something to try to help them out, yes.
So they're still working on it, Mr. Hesselmeyer. Sounds like she'll work on that as quickly as possible. Hopefully, maybe she'll have some news for you by the time she gets there, May 4th. Don't quote me on that, but I know that she'll work at that. All right. Anything else from DHHS today?
No, thank you, Judge.
Mr. Delaney, anything else?
No, thank you.
All right. Mr. Brown? See Mr. Brown anymore.
Oh, sorry, Judge. No, thank you. Nothing further.
All right, Mr. Dowling, anything from your end?
No, Your Honor.
That'll be the order of the court. Thank you all very much. Appreciate your help, Mr. Hesselmeyer. We have one more case this afternoon. This is the matter of the state of Michigan and Logan Weber, file J25-317-NA. If I can have the lawyers place their appearances on the record, please.
Thank you, Judge. Don Summerfield for the Department of Health and Human Services.
David Delaney, counsel for mother in this case.
Larry Brown on behalf of Jesse Kent.
On behalf of the minor children.
All right, I do see Ms. Weber is with us. This is set for a pretrial hearing. Mr. Delaney, how do you want to proceed today?
Judge, we did attend a mediation, and the court may have the mediation report. And I thought that I thought that the mediation process was successful in that it was not a courtroom. Serena had a lot of opportunities to speak with me via Zoom. And we did reach a tentative agreement, excuse me, But at the end of the mediation, Serena either lost connection or didn't continue with the finality of agreeing to the mediation agreement. So I don't know if fatigue got her or she lost communication, but I think we have an agreement, and I just want to make sure that Serena understands that. And maybe I can just ask her, Serena, do you agree with that? We went to mediation? Okay. And did you receive a one-page document from mediation called mediation agreement?
No.
Okay. I'll have to pull my email to see. It looks like it would have gone to you, but I'd like you to have that in front of you before we go any further in the court proceeding, because the mediation agreement would be restated today to the court, and then the court could continue or establish jurisdiction and provide services. Do you understand that process?
I do. I recently moved addresses, so I don't know if it was sent to my old address or the new address, and now I'm currently in rehab. So.
Do you have a new email address?
No, same email.
Okay. My concern, Judge, with working with Serena is that even if I'm able to forward this to her today, it's only a page. She's got to read it, understand it, digest it. And I'd like to give her an opportunity because it was methodical during mediation. I don't want to rush her today on this. If we sent this agreement to you, Serena, and you got a chance to look at it and we came back, would you be ready to go with the agreement?
Yes.
Okay. And let me just say this generally. The agreement was that the court would be given jurisdiction, that is oversight over you and the children. And I think you were in agreement to do that. Is that correct?
Yes.
Okay. So that's my proposal, Judge. And I don't know if the department disagrees with that, but.
Sommerfeld, any comments?
Judge, it is proper if someone is intending on tendering the plea to have the documentation in front of them, demonstrating to the court the voluntariness of things that she understands. And then those would be findings that the court would have to make. And I think we would be at a deficit right now. We do have an agreement. Mr. Lawrence did amend the petition. It involved Ms. Weber. There was a plea in her criminal case that it's the same charges that were the same, not charges. The criminal charges are the same allegations that we have in our petition that allege neglect and abuse under MCL 712A 2B1 and 2. So as Mr. Delaney has promoted to the court, I would be in agreement with that. I know that these agreements are sent out. Ms. Weber did not get one. She did say she was in rehab. But no, I'm getting around to it. I agree.
Thank you. Thank you. Mr. Brown or Ms. Hansel, any objection to us taking a reschedule, basically starting doing this process over again to give Ms. Weber and her counsel an opportunity to discuss matters fully?
I have no objection to that, Your Honor.
I have no objection.
All right, Mr. Delaney, anything else before the court today?
Yeah, just to make sure I'm on the same page. Serena, we're on YouTube, I think, so I don't want to read your email into the YouTube, but it's the one that begins with RE, that one?
Yes.
Okay. And then you also gave me your cell phone number. I won't read that into the record, but the last 4 digits are the 41.
No.
Of yourself? No. Okay. Let's do this. Here, do you have a pen?
I don't.
Okay. I was going to give you do you have my telephone number at the office?
Just a second. I'm getting a pen now.
Okay. Thank you.
Judge, I'd ask Ms. Kirchhoff, she's present from Wellspring, to just give an update on the child that's in Arizona.
Yep, we'll do that before we close the record. Do you have a pen now, Ms. Weber?
Yes.
You have something to write with, so you can take phone number? Go ahead, Mr. Delaney.
Okay, you
wait.
ready?
No, that pen died. Hold on.
Okay, that's it.
Okay, I'm ready.
Okay. My telephone number at the office, and my answering machine's on all the time. The first part is my area code 989 731
Okay.
989-731-1508.
Okay.
And I want you to call me, and my phone was acting up earlier, so if you don't get through today, just check back. There may be a technical problem at my office. Call that number and leave me your cell phone number. So I
Okay.
know how to get hold of you. And I'm in the courtroom right now, but when I get back, I'm going to email you a copy of the mediation agreement. And when you get that, just respond that you received it. And then at the next court hearing, you'll have it, you can read it, and then you'll be ready to put that on the record, okay?
Okay.
Okay, thank you.
All right, Ms. Weber, I also want you to, if you have any questions about what that agreement means or what's going to happen next, I want you to talk it over with Mr. Delaney before the next court hearing. So that the two of you are on the same page and you have all of your questions answered as much as possible beforehand. All right, ma'am?
Okay.
All right, and then Mr. Sommerfeld, if you could, I think we'll take some brief testimony from Ms. Kirchhoff as to how the kids are doing. So Ms. Kirchhoff, if you raise your right hand. For the testimony you're about to give, be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you. Mr. Sommerfeld, your witness.
Thank you. Ms. Kirchhoff, can you state your name, please, and spell your last name?
Yes, Mikhaili Kirchhoff, Kirchhoff.
And how are you employed?
I'm a foster care supervisor with Wellspring Lutheran Services.
All right, we're here today on Logan Weber. Are you familiar with Logan?
I am.
All right, and how do you know Logan?
I am the case manager for his open foster care case.
Okay, when this case started, there was another child. He has now attained the age of majority, is no longer on this petition.
That would be correct.
All right, so to refresh the court's memory, I think it was in the winter time, didn't Logan move to the state of Arizona?
He did, yes, back in November.
Okay, and is he still currently domiciled there?
Yes, he is still in Arizona.
Okay, and he's there with his father, who's a non-respondent?
That's correct.
And that's Anthony Weber, his father?
Correct.
All right, so can you give us an update on Logan's, where he sits in a case posture at this time?
Yes, so I had received a call from a CPS worker in Arizona regarding a complaint that was called in from Michigan on Anthony and Logan. At that point, she wasn't really sure where that would go. I did give her a call back. I got an update today from her. She had reported that at this point, Arizona is not really sure how to move forward. They said because whatever was called in as a complaint. The only thing that they could do at this point is seek legal charges against Anthony for kidnapping, for leaving the state of Michigan. She noted that they could not do like a courtesy visit or anything like that the court had requested without potentially seeking those criminal charges. So I did ask that she and her supervisor contact the department and myself and see if we could set up a meeting to really kind of clarify what's going on, how it got called in as a complaint, and what would need to happen to get a courtesy visit going if that's possible in Arizona.
So if I understand you, Michigan asked a sister agency in Arizona to just check in to see how Logan and his father were doing, and they may be proceeding with criminal charges in Arizona.
That was my understanding. It was supposed to be called in by the Department of Health and Human Services as a courtesy visit. I think it got called into their hotline, and so it ended up coming through as a complaint instead of a courtesy visit, which now makes Arizona legally responsible to determine on whether or not there's a criminal charge there.
Okay, but the child, it really is under the jurisdiction of Arizona at this time.
The child resides in Arizona. She said that they hadn't opened a case. She had not even established contact with the family. There's no like open court there.
What is this person's name and what county, what Child Protective Services county do they work out of?
I did not get her last name, but her first name was Tammy, and she's with the Phoenix Department of Child Safety is their name.
Will you be able to investigate further and get the information to the parties in the court?
Yes, yep. I left my phone number with her. She was going to contact her supervisor and program manager, and anticipated that the supervisor would be giving me a call directly.
Okay, are we in a position to explain that we were just asking for a welfare check and not calling in a complaint about kidnapping?
Yes, I did attempt to explain that on the phone with Tammy today, that that was not the intention of the department. She said really their hands may be tied because of that, but that she would set me up with her supervisor so that we could hopefully clarify the situation.
Okay, do you have anything else to offer regarding the welfare of Logan?
No, I would note that I continue seeing him virtually every month. He seems to be doing well. He's excited to be in Arizona. He enjoys the weather there, of course, compared to Michigan weather. He is enrolled in school online, and he also has some workbooks. Anthony's gotten him set up with a tutor to help with some of that online work, just because it has been a little bit more difficult for him. I've talked with Anthony about in-person schooling and that may be a better fit for Logan overall. But at this point, because they were partway through the school year, he felt it was better to keep him online until a new school year starts.
Okay, Father Anthony Weber, he originally went on vacation to Arizona to pursue a job. Do we know if he's still employed at that where he was originally seeking a job?
He is employed. It's not at the original place that he was supposed to be working. He reported to me that he's working for a rental car agency at an airport, basically driving the cars, making sure they're clean, getting them set up for whoever is picking them up as a rental.
Okay, and that's in Phoenix?
Correct.
Anything else to tell the court?
No, not today.
All right, thank you.
Mr. Brown, any questions for the witness?
No, Your Honor, thank you.
Ms. Hansel, any questions for the witness?
No, just to clarify, Logan's health is well, is it not?
Yes, it is.
Okay. And it appears from my conversations with his dad that his father is attempting to meet his educational needs as best he can, even though it's this online school, but he has realized the importance of keeping his education intact and has tried to do that as best he can from the situation he's in. Is that correct?
Yes.
Okay. I have no other questions. Thank you.
Mr. Delaney, any questions?
No questions, thank you.
All right. Thank you very much, Ms. Kirchhoff. I appreciate the update. Please keep working on that so we don't have somebody thrown in jail unnecessarily. All right. I think that's all for today. We'll look forward to rescheduling this matter as quickly as we can. We'll send out notices to everybody. And again, Ms. Weber, if you could keep in close contact with your attorney, that would be helpful.